Great State of Florida, and on the court.
Be seated, please. Good morning and welcome to the First District Court of Appeal. We have two cases on the docket this morning. And the first one is First American Title Insurance Company versus James Raffone and Patricia Raffone. Hope I've said that correctly. Counsel for the appellant may proceed.
Good morning, Your Honors. May it please the Court, my name is Arthur England. I'm here on behalf of First American Title Insurance Company, and with me at counsel table is Douglas King. Your Honor, I've reserved and would like to reserve 3 minutes for the rebuttal. Your Honors, for all transactions during an 11-year period, starting in July of 1999 and going through March 16th of this year, the trial court has certified a class which is defined as all persons or entities in Florida who paid a title insurance premium to First American in mortgage refinancing transactions in an amount in excess of that allowed by Florida law. That class will require thousands of individual mini-trials, we call them, to determine exactly what persons are eligible to be in that alleged class of being entitled to amounts because they paid more than was Florida law allow under its very unique insurance statute and regulations. Because the claim, and our principal position is the claim of each class member will predominate to determine their eligibility under the 5 criteria that have to be met, none of which are spelled out in that class definition. There has to be a prior owner's title policy on the same property, who had the same owners, for which a title insurance premium was paid by that owner, and both a copy of that policy must be in the title insurance company's file and that of its title agent. Now, Your Honors, we have in our brief noted the wide variations among the 1,500 or more and more than 40 offices of First American where title insurance policies are in fact written, so to speak, on the ground. And we've summarized what is undisputed evidence, which establishes that First American can never determine from its own file whether there is someone eligible for the rate, for 2 very simple reasons. There are 38 title insurance companies in the state, and they only write for one of those. They have no idea whether somebody else has issued a prior owner's policy. And the record establishes that many of the 500 attorneys and over 1,000 title agents who issue policies don't always send First American the copy of the policies they issue. Perhaps they
issue policies for First American, and First American never gets a copy of the policy that's their policy?
That's correct. We have affidavits from the title agents who say some of them don't send. But, you know, part of the issue is, and they've put it in terms of a non-delegable duty, I think it's important for the court to understand what goes on and see how that duty plays out. And the best example in the record is an affidavit we provided, one of 15 from title agents, from Debbie Cahill. She's a title agent in Destin. And by the way, that's volume 4, tab 34 of your record. In her affidavit, she says that her agency, quote, always asks for a copy of the prior owner's policy, unquote, when it gets an order for a title work on a refinance transaction, which is what we're talking about. Her affidavit says she looks at title evidence if they're unable to get a policy and then contacts the law office of the title company that handled the prior closing. So she reaches out to the people who she doesn't have information about. And, her affidavit says, she checks her own files for prior policies on the same property, quote, for every order for title work on a refinance, unquote. I ask Your Honors, what more can a title agent do? What more can First American require of its independent title agents to do? Because at the end of her affidavit, Ms. Cahill says that despite those things, they still cannot obtain a prior owner's policy in 10% of the refinance transaction cases they get. Without the prior owner's policy, Your Honor, there's no eligibility under Florida's unique statute for a reissue rate. So let me jump to what we think the trial judge did wrong in signing the order that was sent by counsel, verbatim except for changes which don't have any analysis here, don't have any requirement. You know the law requires a rigorous analysis by the trial court, and by the way, also by your court. And that means to determine how disputed issues might be addressed on a class-wide basis. You don't see anything in the trial court's order that makes any attempt to meet that requirement. There's nothing that suggests how, and there are no factual recitations whatsoever, how if they were able to prove that Mr. and Mrs. Raffone were entitled to a refund, any other class member that they've defined, that is those eligible for a rate, could possibly be also established. It's individualized. There are people who went into the title office and were told they're entitled to a reissue rate. You have affidavits saying from title agents they didn't want it. They wanted to close now and not have to come back. They didn't bring it with them. They didn't want to come back, go home, maybe not find a policy. How do those people get eligibility under the class definition without an individual trial, a mini trial on their cases? You know, in the city of Tampa versus McAfee, the court said the trial court must anticipate, that's the word, the issues and the kinds of proof that will go forward in the trial. Which predominates? And you have to ask yourself here, will the individual issues predominate, or will what they call a common issue, which is an obligation to follow the law? Your Honor, this is not one of those cases like those that have been decided where there is a contract provision, which, if interpreted, applies to everybody in the class. You have that case. You've had that case in the city of Tampa. This is not a case where a marketing practice, as in Palladino, applied to everybody. You can answer the question in this case, what the requirements of law are for a reissuance, refinance transaction, and you will not have come close to determining whether anybody in the class has yet qualified under our unique eligible statute. You can try Mr. Raffone, and it won't tell you whether somebody else who went into the title agent and, for example, had the roster of activity you saw in Debbie Cahill's affidavit, whether that person had a prior owner's policy. We know 10% they didn't find it. We don't know whether those individual people will be eligible for the rate.
How, in your view, should the obligation to provide title insurance to those with a previous owner's policy, how, in your view, should that be enforced?
I think enforced, there's a lawful obligation.
Well, I understand this is not directly related to the question of class certification, but I'm just trying to get a handle on the general problem here in order to understand the trial court's order.
We think it's being enforced exactly the way it should. Let me show you. Let me mention what the record establishes, Judge Parvano. First American, there is record evidence that it advises all of its agencies to implement the reissue rate because it's required by law. The contract between First American and each of its title agents specifies the entire rate issue, sets out the rate table, and a calculator. And then the bulletin went out in 2006, I think it was, to the direct offices. You must apply the rate, although they were already doing it according to affidavits that we have in this record, by the way, which are uncontroverted. As to the title agents,
is that only if somebody understands that they're entitled to get it and asks for it?
No, far from it. The affidavits establish that the title agents ask people. Now, it's not uniform. They're independent. There are 500 lawyers among that group. They're going to do how they do it, but they've been told by First American to advise people of the rate and to tell them that it's available.
So in other words, there's some notice, at least with regard to your company or your client's company or some of these companies, to provide notice.
Oh, absolutely. And indeed to sign a certificate afterwards saying that they had that information. The record establishes that that also was done. So you have to ask yourself the question, which is the predominant question here? Whether there's a legal duty to comply with the law, which is the question that's been posed by this certified class, or what needs to be done in individual cases to establish eligibility where there are multiple criteria, including something that no other state and no other case in any other state has dealt with, an obligation to put a copy of the policy in the title agent file and in the title company file. First, of course, determining that there is such a policy. The class notification that was proposed here would bring to the table, assemble people who don't have a prior owner's policy. They get the notice, but they never had one. It was described as give notice to all the people who had non-simultaneous title policies on a lender transaction. That would go to people who are buying their first house, people who never had a refinance transaction. How do you sort them out? And again, the answer to your question, Judge Padovano, is that on pages 10 to 15 of our brief, we've summarized for you 22 individual practices of the title companies which try to reach out to the public and say, you're entitled to this rate. We can't make you take it. We don't know if you have a policy. Come tell us. But we give you notice that there's an opportunity for it. And on pages 17 to 18, we've summarized again the direct operations responsibilities undertaken already by First American's offices to get that information into the hands of buyers. This is so dependent upon what individuals would do. Free choice. There are many people who simply say, as I mentioned earlier, I want to close now. I'm here. You told me about the reissue rate. And this is very often the first time that our people have had contact with, because we're talking about lenders' policies that are started with a mortgage company and everything comes down. Come to closing and you're asked the question, did you know there's a reissue rate? Do you want to take advantage? Do you have a prior owner's policy? Did you bring it with you? Well, no, I didn't. I didn't know that. And what am I going to do? I'm not going to go back now. I saved $80, $100. It's not worth my time. Or I don't know where it is. And those people yet would be included in this class with this common legal definition that goes nowhere. You know, Your Honors, I found it interesting that on page 14 of the answer brief, they state affirmatively that decertification would be appropriate if liability depends on what was done or not done or known and not known. And that's, of course, exactly what liability is dependent upon. So they want you to do something abstract. They wanted the trial judge to do something abstract, like decide a legal question. Save that for later. Trial judge never exercised his responsibility. Predominance is more demanding than a common issue. The courts have said that. But class action is nothing but a procedural device. It doesn't change the burden. Every individual is going to have to establish eligibility. And no other case you will find, or none that they have cited, has that included having to bring a policy, establish a prior policy, and bring it to the office of the title agent and put a copy there and in the title company file. You know, it was interesting. They filed a notice of supplemental authority with the Campbell decision, a Maine judge decision. Maine law having no requirement of a prior policy requirement, no requirement to place anything in the pile. But it was so interesting that the judge started his analysis with a series of recitations from the case and said, each title insurance overcharge case inextricably is tied to state-specific title insurance regulations. And that's the problem here. Your Honor, I see that I have a bit of encroachment on my rebuttal time.
Not too much.
Thank you.
Good morning, and may it please the Court. I'm John Mills on behalf of the appellees. With me at counsel table is Robert Axelrod, the trial counsel. I think the first thing, which of course wasn't mentioned in my brother's argument, is the standard of review. The standard of review, because it's class certification, is abuse of discretion. And in a recent per curiam affirmance citation, this is an opinion, Judge Padovano, you were on the panel, and I think it's pretty typical of cases like this. The opinion said the order granting motion for class certification is affirmed, cites 7 Hills from this court, which said abuse of discretion applies, and that no reasonable judge would have granted certification as the standard, and the Chase Manhattan case, doubts about class certification should be resolved in favor of certification. Again, the abuse of discretion, you have to conclude that Judge Davis did what no reasonable judge could have possibly done. To reach that conclusion, you have to not only decide that Judge Davis did something that no reasonable judge could have done, but that 4 other circuit judges did the same thing. We've got 4 judges in 5 cases that were settled on the exact same claims, Florida law against title insurance companies, exact same situation. Now, 5 of those cases were settlement cases, but the Amchem case from the U.S. Supreme Court says you actually apply the same test but heightened scrutiny. And those courts all found that Rule 23b3 was met. One of those cases was not settled, the Blake case. That case was opposed. A circuit judge certified a class in that over the same kinds of arguments here. If you read the trial judge's opinion, that's in the appendix, exactly rejects this exact argument that these individual circumstances are relevant to the issue. The only DCA decision, there have been 2 DCA decisions to involve this issue, one out of the 2nd District. You would have to conclude that a panel of the 2nd District, including Judges Northcutt and Altenburn, the trial judge in that case, Nellie Kazam, you would have to conclude that they were unreasonable in concluding that a class could be certified on the exact same claims that we have here. Now,
but is the question whether a class should be certified or how the class is the bigger controversy here? Really, how should the class be defined?
They raised that. We have the fail-safe argument, but no, I think the big issue is, can a class be certified here? And they argue, their argument is that you have to look at these individual issues. That's the class definition. The class definition is if you had the owner's policy, you're in the class. If you did not, you don't have the class. The only issue to be tried that's disputed, that's going to be resolved, is the legal issue of, is the existence of the policy entitle you to the reissue rate? We say that it is. They say that no, you have to look at, well, even if there is an owner's policy, were you asked for it? Did you provide it? Did you decide you didn't want to provide it? They try to put the burden on the agents or on the borrowers most often to present the policy. And if they say you come to closing and, well, the agent asked, do you have a policy? And if you do, you have to have it with you or you don't get to refinance. We don't close. You can go back and bring it back and we can push off the closing and we'll have a new closing. And of course, if you've ever been to a real estate closing, you know that means more money and that's a false choice. So that's why people say.
But the rate on a refi, the rate for the title insurance on a refinance applies even if you've got the original title policy from another company, correct?
Correct.
Okay.
That's correct. And our position is, and this is the issue that is disputed, you can break it into sub-issues, as I think they do, but it's really one overarching question. And that is, do you get the reissue rate if there was an owner's policy? They say, they come up with all these reasons why. Maybe you don't. And it's because you didn't do something. You didn't present it. You signed a waiver form. They come up with all these, quote, individual defenses. But they all boil down to the same legal question. And Judge Davis got it exactly right. He said that the first step in this litigation is to answer that question. And that's the merits question here, is are the plaintiffs correct that having the policy, that it's their duty to price it accordingly and they have to go find it? And if they're told that there is a policy but I don't want to bring it, then they got to go find it. Or if there is a policy, they need to find it. Now, they bring up these questions, these problems of, well, how are we going to find a policy if the owner doesn't give it to us or we can't control these other agents? If there's not a policy out there or it can't be gotten, then that person's never going to have a claim. If we prevail on this common issue, there's not going to be a single mini trial. There's not going to be anything that's going to be disputed. If we prevail on our legal issue, then everybody who's in the class gets damages that are easy to calculate.
But you're also saying if you don't prevail, it should be decertified.
It depends on how we don't prevail.
Okay.
It depends. If, for example, Judge Davis rules on the merits, and again, you cannot decide the merits. You look at what the legal issues are going to be, and that's what he did, but you don't decide them. So if this is affirmed and we go back and there's a class certification trial, then Judge Davis will decide these individual defenses. For example, they say First American had a waiver signed that was formed, and that only applies to part of the class from 2006 forward. Before that, there was no waiver form. So if they prevail on that argument, that anybody who signed that waiver form doesn't get the reissue rate, even though they would otherwise be qualified for it, then you've got two subclasses. Anybody who signed that waiver form is in one, anybody who didn't is in another. And if you say signing that form is it, then that class loses. They lose, and they're bound. If you have a determination in our favor, then the class prevails. If they prevail on their argument that, well, it's the agents and not us, then you could have some classes as to those. And if they ultimately prevail on their main argument that you have to look, there's a presentment requirement, and it's up to the owner or the borrower to provide the policy, and if they didn't do that, if they prevail on that issue, then decertification probably is in order. There's probably nothing. Then it probably will require each person who has that policy would have to file an action in county court over a couple $100, hire a lawyer. There's no prevailing party attorney's fees provision here. So to answer your question, Judge Padovano, absent class certification, this cannot be enforced.
Well, one of their concerns is they don't know who had a previous owner's policy, or they say that would be difficult to figure out. Mm-hmm. I understand that argument, but the way that the class certification or the certification order is drawn, it includes anybody who is entitled to this rate, presumably somebody who had a title insurance policy and for whom they were not aware of. So now it comes down to you to figure out who these people are. How are you going to do that?
Right. Well, that's the hard work in this case.
Well, that's the problem. It seems to me that this merits issue that you're talking about is connected all up with the question of who's in the class, isn't it?
It is, but it's a problem. The case is about whose problem is it. Our argument is it's their problem. And it wouldn't have been a problem if in each individual transaction they satisfied the duty that we said the law imposes on them.
If the trial court rules, for example, on the merits of this thing, that the title insurance companies have an obligation to find out however they can, mm-hmm. who had a previous owner's policy, then this rather broadly defined class would be okay, right? But what if that's not the ultimate determination? What if the determination is that the law only requires them to provide notice to a landowner that they're entitled to this discount if they come forward with the documents? Now you've fractured the class up, haven't you?
You sure have.
Okay.
You sure have. But that's a legal decision on the merits of the claim. And if that's made, then just like the Ohio courts did, in a case where they determine where Ohio law does require presentment, or at least that the borrower present some information of a policy, the courts that had certified a class in that case, because it appeared up front, we've got a common issue to decide, well, once you get into the merits and resolve an issue on the merits, then that goes away. In your example, if that's determined that this waiver form is a valid defense, well, then Judge Davis has a wide variety of options in his discretion on how to handle that. One might be a subclass of whoever got a waiver and whoever didn't. Another might be a claims form. We'll just have a claims form. Were you advised? And anywhere if somebody signs that they were not advised and there's no dispute from the other side, there's no mini-trial required there. And anywhere where there's a dispute, then the class could be decertified and there could be individual trials on that issue. But the key point is that the determination of this common legal issue will resolve this issue once and for all for everybody in Florida involving First American. That's the only way we can get there, is a determination of what's required to win this case. Is it just required, as the plaintiffs say, to have the policy in existence, or does there have to be more? Do there have to be the individual circumstances that they suggest are required? And so if we have a class certification order, if that's affirmed, and Judge Davis makes his determination of what Florida law requires, that determination will bind everybody in this case. It will bind all class members, and it will bind First American. So if First American wins on its defense, then this issue is largely resolved. And each individual, if it's decertified, even though it's decertified, that ruling, just as in Engel, would apply to all of the members of the class, and it would bind against them. And so if they had a policy and they just didn't bring it in, and the court ruled that you have to bring it in, then they don't have a claim. If they think they brought it in, then they might have a claim. But that would be...
Decertification is always a possibility, but is the procedure here in class certification to say, oh, let's just go ahead and do it, we can always take it back? I mean, that seems to be kind of the argument that you're making. I mean,
No, it's not that we can always take it back.
I mean, decertification is always a possibility, but shouldn't we be trying to get this right to begin with and not sort of rely on that as sort of the way to get ourselves out of a jam if we make a mistake?
You're absolutely correct, and I think that's the right way to look at any case where there's a claim, well, it can be decertified later. We're not saying it can be decertified later because of problems that we know exist right now. We're saying it can be decertified later if we lose on the merits of our legal claim. And the determination of the merits of the legal claim are not supposed to be made at the certification stage. They're supposed to be made afterwards. And the reason for that is it wouldn't be fair to First American or the defendant if you decided the merits first. Because if you decide the merits before class certification and the defense wins on the merits, then that doesn't bind anybody but the class representatives. And you're going to have separate trials, and in each separate trial, somebody could bring that claim all over again and say, well, no, that was wrong. I'm not bound by that. And so here we have a legal issue. That's the only thing there needs to be a trial over. And it probably doesn't even need to be a trial over that. That's probably summary judgment material. This idea of mini trials, I defy them to name one mini trial that could take place in this case. If you're a class member, you've got a policy. Okay? So if we prevail on the issue of you've got a policy, you're entitled to reissue rate, then there's not going to be a trial. Either there is a policy or there's not a policy. That's not something that gets litigated over. There will be discovery requirements. There will be an attempt to find all of these class members, and we know that all of the class members are a subset of a group of people who purchased or paid for non-simultaneous issue lender policies. We know that most of those people, but not all of them, most of those people had prior owner's policies and were entitled to the reissue credit. So we're going to send notice to all of those people, and that is notice to the entire class. Anyway, I just lost my train of thought. This same claim has been certified going back to the standard of review by trial judges, not just every trial judge in Florida to consider it, but district judges in other states. And the Campbell case is right on point, even though you do need to look at the differences between Florida law and Maine law. My brother is absolutely correct. But our position is that Florida law does not require presentment. Their position is that it does. And that's the common issue that's to be decided. The only appellate decision from the federal system to look at this was the Mims case in 2009. In 2009, the Fifth Circuit held that a district trial court in Texas did not abuse its discretion in certifying this exact same kind of class. And they said they rejected the argument that the equitable nature of the plaintiff's state law claims require an individualized factual inquiry, because under Texas law, disclosure of the discount and waiver are irrelevant, because the rate rule sets the maximum amount that title insurers may charge for reissue title insurance. That's the same issue here. That's our position, is that Florida law is just like Texas law. They say we're wrong, and that Florida law requires, because it says there has to be a copy of the policy in their files, that requires the borrower to present the policy. That's the legal question to be decided in this case. Once that legal question is decided, all individual issues will either go away, if we are correct, or will become important and may in fact predominate, in which case the class would have to be decertified. But until there is a determination of exactly what Florida law requires, the only issue that is being argued about in this case, until that is resolved, we can't know whether the class will ultimately succeed. And Florida law is quite clear that at the class certification stage, the trial court and the appellate court are not supposed to be resolving the merits. And to resolve the merits here, you would have to answer that question of, does Florida law require presentment or not? That question needs to be decided after class notice has gone out. Anybody who doesn't want to participate can opt out. At that stage, everybody will be bound by that legal determination. It will be right for determination on a class-wide basis. If we prevail, the class wins, and it's just a ministerial function of finding those policies and sending refunds to the people who had them. If we lose, then it can be subclasses or it can be decertified. Thank you.
Your Honors, the question was attempted to be answered on why there was an abuse of discretion by the trial court. Simple. The trial court did not make the rigorous analysis or the determination of what these trials will be like, no analysis that the law requires. This is not like the 4 settlement cases, which, after the legal question is answered, there will be no trial. There are no individual issues. This is not like Bleish, where there was no determination, no argument about predomination. It was decided on standing, whether the plaintiff had the standing to be the class representative. This is the first and the only contested case where you have the issue of what predominance means under Rule 1-220.B3. Judge Padovano, you said correctly, this court is obliged also to apply a rigorous analysis and not wait to see if decertification is appropriate. And I got a challenge. He said, I believe he said, I defy counsel to name any issue where there'd have to be a mini-trial.
I love to hear things like that, don't you?
I welcome those. Yes, Mr. and Mrs. Raffone had their policy in the title agent's file, Almond file. What other case needs a mini-trial? Someone who didn't have their policy in his file. And then you get into what did he do to get it. He testified that he told all his customers this was an inadvertency, a mistake in his office. The mini-trials are everybody else, and that is approximately 500,000 individual files. Your Honor, I don't think it could be better said than the Texas District Court said in Hancock, which is the problem with the position you're hearing. And I quote, although this case presents common questions in a colloquial sense, because there's some same battery of questions that needs to be answered for each possible member of the putative class, there is nothing class-wide about the plaintiff's proposed question that predominates. Each borrower's claim presents an insular inquiry, whether the reissue credit was properly applied or withheld in that particular case. And because of Florida's unique statute, that is exactly what needs to be done. The Campbell case, he said, is the same, involved a situation where there was no prior policy obligation and none to have it in the file. Under that state, Maine's rules, they could certify a common legal question and everybody fell in it. If you had a policy within the 2 years and you didn't get the reissue rate, you're home free. Can't do that here because of our unique statutory requirements. Thank you. I see my time has expired.
Thank you, counsel. We will call up next the case of Commonwealth Land Title versus Kenneth Higgins and Dee Dee Higgins.